Bon, chers invités.
Dear guests, we're now going to resume our session for this last round table before lunch. Extraterritoriality, can it be contained? Now, the practice of extraterritoriality is a major practice in international relations, and therefore it's a fascinating topic, but it's a difficult one. And it is with two experts that we had the study, the research study with as a topic, extraterritoriality. So it will be very interesting to hear the conclusions of your research. So you have the floor.
Mesdames, Messieurs, chers collègues, c'est un grand...
Ladies and gentlemen, colleagues, what a great honor to be here before you today. Thank you to the Academy for inviting me. Thank you for allowing us to present briefly the results of the 2019 Study and Research Center work. I was very honored to chair it together with Professor Buxbaum from the United States of America. It really was an exceptional moment for us. I think like all research centers, we had this beautiful premises. It was ideal in terms of studying and researching. Approximately 20 students who looked at extraterritoriality together, and yesterday we were able to present the results of our work. So I shall give you a brief overview of what we did. I will try to talk you through the different issues that we discussed that have to do with extraterritoriality. We've tried to focus on a couple today. Hannah and I would like to speak about the results of what the Centre did. We've tried to summarize things, and we've tried to, of course, answer the question that was put to us, namely, should and can extraterritoriality be contained? So we'll start with that by way of an introduction, and then we will hear from our researchers. Thank you very much for being here. Farah Julie Yassin from the Kuwait International Law School, and Victor Stoica, who is an assistant professor at the University of Bucharest in Romania. Thank you for your kind presence. So very briefly, allow me to answer, or attempt to answer, the question, should and can extraterritoriality be contained? And I do that on the strength of the work we did and the conclusions that we were able to draw. First of all, I would say that it's not really my job to answer the first question. I mean, I'll come back to it in my conclusion, but I want to leave it open for now, a bit of suspense. Should extraterritoriality be contained? I think that's a political question, maybe even a moral consideration. It depends on how you view the international community. You know, to what extent extraterritoriality has a link with the role of states. Now, in our publication, we present some comments. Some researchers work specifically on this. It's a tool. It's a kind of political foreign affairs tool, if you like, external affairs tool. Is it a tool that should be used or not? That is a different question. And if so, how would it be used? I think that these issues are not really legal in nature. I think they're more political in nature. Now, the other question, can extraterritoriality be contained? That is a legal question. Because at the end of the day, what we're looking at is international law. Can it contain extraterritoriality? Yes or no? And I'm going to speak about extraterritoriality as an attempt by a state to apply its domestic law, its internal law, to facts or to individuals of different nationality or to events that occur in a different country. There are, of course, other aspects when you're talking about extraterritoriality, but these are the ones that I wish to focus on. There are many examples, a plethora of examples, many that have been discussed, and very often they come actually from US law, American law. These are the best known examples. Foreign Accounts Tax Compliance Act, for instance, the Cloud Act, the Rottenkoff Act. There are many examples from the USA, but there are actually also some European examples. For instance, GDPR, General Data Protection Regulation, and again, there are extraterritorial aspects attached to that. So once again, I come back to my question, can international law actually contain extraterritoriality? Having researched this, I would say that yes, international law can contain extraterritoriality. However, it can only do it to some extent, up to a point, in other words. International law does contain extraterritoriality, and I would say that's true for several reasons, and they're not really moot as such. For instance, a state who wants to apply legislation to certain facts or certain individuals, that state will need to rely upon an entitlement, a title, if you like, a right. That is not moot. We have, of course, full knowledge of what you can apply in this case, territorial or personal standing. Also, there is a primordial limitation. I refer you to the Lotus judgment by way of a precedent. I mean, when I talk about extraterritoriality, I always try to avoid talking about Lotus, but I always end up talking about Lotus. Apologies for that. It's almost inevitable. So, a state cannot develop its executive power on the territory of a different state. I think that is agreed and not subject to debate at this point. Then a final point that allows international law to contain extraterritoriality. This is the need for a link, a connecting link. There has to be some kind of articulation between the individual or the event and one of the reasons for which you have right to act that I spoke about earlier on. Now, international law will only contain extraterritoriality up to a point, as I indicated earlier. So in order to unpack that, I think you need to make a distinction between the whole question of your entitlement and then the connecting links. The entitlement is a legal category. It's been identified. We know exactly on what basis you can act in this fashion. But within that, of course, you also need to have elements that connect you to the event or the person. And for that, you need to operate a legal categorization or classification. There's no list. There's no such list of examples that could be quoted because it depends on the circumstances. I mean, one link would be nationality. I don't think that's much disputed. I mean, if you are the national of a state, then you are connected to that state. You are linked to that state in a personal, individual capacity. So nationality is one thing. Or the place where the event took place or the place where the person is. Again, if it's on the territory of a state, there is a link. Clearly, there's a connection. Those are well-identified scenarios, but what about beyond that? That's where you start running into problems, and it's very difficult to contain extraterritoriality over and beyond those very obvious examples. And, of course, there are aspects that relate to our everyday life, such as digital data. Digital data, we use them day in, day out. Try to localize them. Try to identify where they are. Almost impossible. I mean, data geolocated because it's on a server that happens to be situated in a given jurisdiction, or are you talking about access, having access from the territory of a state to that data? There's no objective answer. There's no clear answer when it comes to digital data. Other example that I could quote, transactions with currencies, dollar transactions. For instance, if you look at the doctrine, the legal scholarship, if you look at what experts have to say, some will say, well, any US dollar transaction means compensation possibilities on the territory of the USA. So in other words, there's a link to the territory of the USA, whereas others will say, well, actually, no, it is a virtual transaction. It's completely virtual, and therefore it's very loose, and therefore you cannot actually link it to or pin it down to a particular territory. That's very, very briefly, the gist of it. I'm trying to talk you very quickly through the different aspects that can arise in your thinking. How and under what circumstances can international law actually contain extraterritoriality? I've given this a lot of thought, and particularly with the drafting of the introductory report. I mean, the centre was held a few months just before lockdown. And so we were able to think about extraterritoriality whilst being locked down, so to speak, in the comfort of our homes. We were not able to move beyond our homes, and that's where we thought about extraterritoriality. And that's quite remarkable. I think it's also something that connects with the issue of being able to oppose this criterion against other things. You can only really invoke it vis-à-vis states that accept this principle. And I think the more the claim for extraterritoriality takes into account the interests of other states or interests that are common to the different states, the more likely it is that this claim for extraterritoriality will be accepted. The more you take into account the other, the less it will be controversial. I think that generally speaking, when it comes to certain crimes, it is well accepted. But in other scenarios, it is less accepted. The OFCPA, for instance, or indeed the US Act on Anti-Doping, which has been much critiqued, by the way, by the sports associations concerned. Anyway, be that as it may, ultimately, we come back to the first question, the one I didn't answer. It's for states to determine whether extraterritoriality should be contained, yes or no, under international law. That's a matter for the states. Thank you for your kind attention.
Bonjour. Good morning.
Gentlemen, it has been for me a pleasure and an honor to direct the Center of Study, because we're extremely proud to have worked with the participants and to present the conclusions here today. And the book with our collective efforts is there for your benefit.
Which asks about the containment of extraterritoriality, in a sense makes an assumption about extraterritoriality, which is that it is, to use the technical legal term, bad. That is, I think, the assumption that we generally bring to the consideration of this topic. The term has acquired inescapably negative connotations because we tend to associate it with one particular type of practice, and that is a state's regulation of foreign activity without the consent, or worse, over the objections of the state in which the activity occurred. Yet while that practice has become common, particularly in the area of economic law, it is not at all the only form of extraterritorial governance. Exercises of legal authority that affect persons, activity, or interests outside the lawmaker's territory take many forms and serve many purposes, and in many cases, I would argue, are not objectionable as a matter of international law or policy. So the goal of my report was to explore the complexity of the practices of extraterritoriality, practices, plural, and to assess the normative consequences of the incredible persistence of the territorial paradigm in international jurisdictional law. In the short time that I have today, I will share just a few key conclusions. First, the extraterritorial application of domestic law in order to protect or promote local interests, particularly in the area of economic regulation, has become utterly routine and should no longer be thought of as an exception to jurisdictional rules. This is due, of course, largely to states' response to economic globalization and the reality that it became difficult for individual states to effectively regulate local conditions with purely territorial laws. A dramatic expansion in this form of regulation resulted from the adoption of the so-called effects doctrine, under which states claim the authority to regulate even wholly foreign conduct on the basis of its effects within their territory. And I think it's important to note here, Thibault mentioned that this is not only a US practice anymore. He mentioned the EU practice under the GDPR. I would add the EMIR, Framework for Market Regulation. But this is not just the US-EU axis, right? If you look at countries around the world, through Latin America, through Asia, as countries have developed mature markets, they have expanded their own extraterritorial regulation in areas like antitrust law, market regulation, intellectual property regulation. So this is a very common form. Second, and this is important, a lot of what we describe as extraterritoriality is really territoriality, but in a form that relies on very weak territorial links to justify very expansive regulation. So So the United States, for instance, frequently relies on weak territorial links like the use of UA payment systems or the wiring of money into or out of the United States in order to justify unilateral of foreign activity under taxation, money laundering, and sanctions regimes. I'll just say BNP Paribas, right? In the EU, Joanne Scott has explored this issue under the rubric of territorial extension. So she examines laws that require a territorial regulating state, but that then draw foreign as well as activity within their scope. So one example she provides is the regulation of airlines under the initially proposed emissions trading scheme. So she noted that the proposed directive rested on a territorial trigger in that it applies only to flights that arrive to or depart from the United States. But once that trigger was met, it would have required regulators to charge allowances based on the total volume of emissions generated during flight, not only the portion in the EU. So the reason this is important is that, I'm saying here it's important to recognize that we use the word extraterritoriality to talk about regulation that actually rests on a territorial basis. The reason this is so important is that although doctrine in this area relies heavily on geographic facts, the point of calling something extraterritorial is not to say something about the physical space in which a state acts. It is to say something about the legal space in which a state acts. And the relationship between physical space and legal space is fluid. It shifts across contexts and over time as a result of changes in international law, changes in modes of human interaction, changes in our own conception of what sovereignty is. And so the label of extraterritoriality simply becomes less and less useful over time. My third major conclusion is that states increasingly expand the geographic reach of their laws, not in order to protect or promote their own interests, but to advance international interests. This trend is particularly pronounced in the area of international criminal law, where extraterritoriality has been, in a sense, multilateralized. We have many treaties that address the most serious international crimes, for instance, torture, forced disappearances, acts of terrorism, by using domestic criminal law as a tool to enhance enforcement. So these treaties require member states to criminalize certain offenses in their own national regimes, and then to prosecute offenders where possible, where there have been violations. So these extend the geographic scope of state criminal law to cover offenses that are committed outside state territory, right? Usually on the basis of nationality of the perpetrator. There has also been a noticeable expansion of international treaties addressing crimes that by their nature involve conduct in more than one state. For instance, foreign corruption, transnational organized crime, trafficking in persons. These are almost by definition transnational crimes. And so the treaties, once again, ask member states to deploy their own domestic criminal law extraterritorially in order to address these problems. So this multilateral mechanism affects the normative dimension of extraterritoriality. Traditional accounts use extraterritoriality as a synonym, I think, for overreach, for illegitimacy. But when claims of extraterritorial authority are sourced in multilateral treaties, they, of course, are of a completely different character. Finally, if I may put this last point in a somewhat provocative way, principles of international law are becoming increasingly irrelevant to state determinations of their own law's scope. In general, all international law does at this point is set a very low threshold requirement of a genuine connection between the activity in question and the lawmaking state. And as a result, the mechanisms that we use to contain extraterritoriality, such as they are, tend to rely more on comity and on local practices of statutory interpretation than on international law. Let me conclude by highlighting one future direction for extraterritoriality, which is as a tool to advance global interests or to secure global goods. One illustration of this development that is unilateral in nature is the work of the European Union to use unilateral extraterritorial regulation in an effort to combat climate change. So again, the proposed emissions regime was an example of that. The ship source pollution directive is another example. And the EU has been quite upfront in saying the international community is moving too slowly, and so we will move. Right? We will start to use our internal legislation extraterritorially in an effort to secure this very important global good, right, to address climate change. Another illustration is more multilateral. In the area of business and human rights, the United Nations guiding principles encourage states to regulate the activities of their own corporations and their corporation subsidiaries in other countries. So the principles adopt an explicitly extraterritorial dimension, encouraging states to implement local laws that will then operationalize greater control over foreign activities. These emerging practices, to me, underscore once again the multidimensional nature of extraterritoriality and the need to move toward a more nuanced and functional understanding of the role of state legal orders in the global era. Thank you.
Bonjour.
Good morning. I'm really happy to be with you today and to be able to take part in the centenary of the Academy and to make my presentation today. It was part of the book of the study, the Centre for Studies of the Academy. It was also the result of our research work, which was carried out here in the Academy in 2019. My contribution is being made in the context of human rights. So needless to say, I'm going to be talking to you about extraterritoriality as a protection tool of human rights. The previous speaking was saying that it can serve as a tool to protect the commons, but I will try to see how extraterritoriality can serve as a tool to promote and to enhance human rights. And I shall attempt to answer the question asked today, namely whether extraterritoriality can be contained. And I would also like to add whether in the area of human rights, extraterritoriality should be contained, can it be contained? And in actual fact, do we really want to contain it when it comes to human rights? And therefore, in the time I have at my disposal, I shall try to answer that question. What are the fears which we feel as regards extraterritoriality, and why do we think that it should not be contained? Well, first and foremost, states have argued that the fact that all these obligations are imposed extraterritorially might in fact discourage them from taking part in military operations, such as the ones carried out by NATO, for example. Furthermore, states don't all share the same legal cultures as regards the obligations incumbent upon them. For example, Canada and the USA very often take part in military operations abroad, together with member states, say, of the Council of Europe. And those countries, of course, are under obligations under the European Convention. And hence, I would say that these differences in legal cultures may have an influence on the interoperability amongst those states. But I shall try to demonstrate that regardless, or no matter what those fears may be, it's always very important to apply extraterritoriality in the area of human rights. Why? Well, it should be concerned that it is both accepted and upheld. In respect of human rights. I'm not going to dwell on the legal analysis which is set out in my article to explain the case law basis, etc. But in a nutshell, may I say that we have in fact moved from territoriality to a presumption of territoriality to a form of deterritorialization in the area of human rights, and therefore the presumption provided for under Article 29 of the Vienna Convention could be reversed under other presumptions, case law presumptions. There are international instruments, but also regional instruments, which have in fact made it possible to confirm extraterritoriality in the area of human rights. But as was mentioned by Professor Fleury-Graf, there has to be some attachments, some connection, some elements. So, in fact, we don't all agree about what is required. Some bodies speak about an effective control, others are more flexible in this area, and they speak about influence. Or again, certain theories are emerging and dwell on the notion of attribution, that is to say that the effective link is not really required, or it may well be required, but its interpretation can be flexible as to contain the activities which are being carried out outside the territory under the control of the state, but provided that the persons concerned should be affected by the military operations carried out by certain states. Therefore, there have to be certain connecting links, and the link has been identified by certain bodies, less so by other bodies. And therefore, this analysis, in fact, leads us to accepting a factual analysis, which isn't merely based on jurisdiction, in order to connect certain obligations to certain states. Obligations, of course, which are imposed outside the national territory. But I think the most important element to answer this question, namely whether or not extraterritoriality needs to be contained, is that the extraterritorial application in the area of human rights leads to broadening the area or the field of protection. And when I say broadening this area, I mean by that we're talking about the extension of the ratione personae and ratione materiae scope of this application. First of all, as regards the ratio materiae application, human rights now govern situations such as that of occupation, for example. We saw in the Skene case, for example, that obligations are incumbent on the UK for acts which were committed in Basra, in Iraq, because the UK was an occupying power in Iraq. Or again, other obligations flowing from human rights can be imposed on international peace-building or peacekeeping missions. I'm not saying that all of that is set in stone in international law. That goes without saying. The Human Rights Committee, in fact, invariably accepts that the international covenant can apply to these peacekeeping forces, but we should acknowledge that this, in fact, is based or depends on the mandate of the forces which are being deployed. At the end of the day, it depends on the mandate in order to see what obligations are incumbent on those forces. It should also be added that today we can see that human rights can, in fact, be involved and obligations are incumbent on forces involved in military operations abroad. And the Human Rights Committee accepts this application of human rights, for example, when it comes to sporadic acts, targeted killings, etc. It's a view that isn't shared by all international bodies. Let's be clear about that. The matter is far from being settled, as I say. I would also like to add another advantage as regards the extraterritorial application of human rights. Henceforth, individuals have more fora to rely on human rights, be it at international or indeed regional level, and therefore sometimes people who are very far removed in legal, cultural, or even geographical terms from the context or indeed the territories, the territories where the alleged violations have been committed, well, those individuals can bring legal proceedings in order to avail themselves of their rights. Sometimes these are individual proceedings or interstate proceedings, and in that connection, I'd like to say that opening up avenues for additional remedies can also possibly enhance the effectiveness of the mechanisms for the application of human rights, and especially at international level, at the level of the United Nations. Why? Because the special procedures of the UN usually have regard to the conclusions of the Human Rights Committee or advisory opinions or decisions handed down by the International Court of Justice. I think I've still got a minute left, so I'll just conclude. I think it can be said that extraterritoriality is well established in international law, although the precise contours of its application in respect of human rights are not clearly defined. It should also be added that in that particular framework, i.e. of human rights, the extraterritorial scope of obligations incumbent on states leads to an increased protection of human rights, an enhancement of human rights, as I've tried to explain. And therefore, do we really want to contain, to limit this extraterritorial application? Not really. Not really, because in fact it enhances and extends the protection of human rights, as I have explained several times. And therefore, as regards the legal issues which are raised, it's better to deal with those rather than containing the implications of extraterritoriality. And I say as well that that might also foster the humanization of international law, of which a great deal was said yesterday. And together with all the panelists, I'd like to say that I'm totally in favor of the humanization of public international law. Thank you.
Excellencies, dear
Excellences, chers amis, chers collègues, c'est un plaisir que d'être ici aujourd'hui. Je voudrais remercier l'Académie
be here today and to listen to all the very interesting and thought-provoking presentations and to hopefully contribute with a little more thoughts on how extraterritoriality applies in cyberspace. My contribution to the work of the Center of the Academy in 2019 revolved around the concept of cyberspace and cybersecurity. And the title of my paper was Testing the Continuous Viability of Traditional Jurisdictional Norms, the Challenges of Cybersecurity. It was very challenging for me because cyberspace as a domain is perhaps the best representative of extraterritoriality. When we think about cyberspace, the norm of territory no longer applies, in my view. It is rather an exception, while extraterritoriality becomes a rule. So my chapter focused on addressing whether the traditional jurisdictional norms which are anchored territorially apply in cyberspace, and whether the extraterritorial application of norms should be considered as a rule rather than as a norm, and consequently whether this rule could be, and to address the question of today, could be and should be contained. First of all, from the outset, I think it is important to keep in mind that cyberspace is a really complex domain. And here, if we think about activities, if we think about the actors, if we think about the application of law, be it national or international, all these interactions, all these tensions contribute to the increasing complexity of cyberspace generally, but also of the activities performed in cyberspace. We have a diversity of actors performing in cyberspace, be it public, be it private actors. It is complicated, though, to differentiate between these two. It is very complicated to determine, for example, how the rules of attribution apply to actions performed in cyberspace. If we think about the activities, also cyberspace is really complex because, and they are increasing in their complexity. The activities performed in cybercrime may involve, in cyberspace may involve simple cybercrime, but other activities performed in cyberspace may even shut down industries. We see more and more this concept of cyber attacks, cyber interference. So the activities performed in cyberspace are often equal in their negative effects to veritable acts of war or armed attacks. The application of law is also an interesting topic. National and international law, we know today that they clearly apply in cyberspace. At the beginning of the 1990s, we had certain liberal activists that said that cyberspace should be governed by nobody and that no rule should apply in cyberspace. No governmental authority should be taking care of the activities performed in cyberspace. But today we see that regulation applies, the existing regulation already applies, but there is a need to calibrate the existing regulation and to fill certain gaps generated by the existing regulation. So there are three main points, main issues that influence the application of national and international law in cyberspace, and these revolve around, first, the possibility, or rather the impossibility, to localize actors and actions. Second, the need for regulation or the need for calibration of existing norms. And thirdly, the territorial and extraterritorial of the application of existing norms. So please allow me now to turn to extraterritoriality. What I studied in my chapter was whether the traditional tests of extraterritoriality, prescriptive extraterritoriality, apply in cyberspace. And states can still rely on these principles, but as I mentioned earlier, they need to be calibrated. Then, at least with respect to cyberspace, we may see that extraterritoriality becomes the rule rather than the exception. The subjective territoriality test implies that the state on the territory of which the perpetrator performs the criminal conduct has the power to prescribe that conduct. In this respect, activities performed in cyberspace are challenging because it is rather difficult to pinpoint the perpetrator. The perpetrator usually has a virtual presence in this space. We talk about virtual identities. We no longer talk about physical identities. So in this virtual area, it is rather difficult to identify and to pinpoint where the perpetrator is located. They can use servers, they can use various IP addresses, they can use different web pages to hide behind certain hurlers and to stop the authorities to find their location. So the traditional physical, geographical parameters of identifying perpetrators does not necessarily apply, does not always apply for illegal activities performed in cyberspace. Logical, decentralized parameters of identifying perpetrators are rather more useful for identifying them and for applying the law. So it is also rather unclear where the action takes place. So not only it is difficult to find the perpetrator, but it is quite difficult to see the effects of that action. So subjective territoriality is generally regarded as a rule, but in cyberspace it's not necessarily so. So what I turn to think about is whether objective extraterritoriality applies in cyberspace. And we have the effects doctrine, which is applicable in generally, and it's also applicable in cyberspace. And this effects doctrine briefly mentions that the action it's applicable in situations in which the action takes place outside the territory of the forum state, but the effect of that activity is within the forum state. In cyberspace, because we do not necessarily have a physical territory, it is difficult to pinpoint the effects of a certain activity. So for example, if we deal with a virus that is sent in the system on the territory of one state, and that virus may have the potential to spread beyond the intention of the perpetrator even. So it is difficult to conclude where these effects manifest themselves. So the danger, if we apply the effects doctrine here, is that we might see a multitude of claims dealing with the same incident, multiple assertions of jurisdiction based on a singular perpetrator and a singular activity. So we have the effects test is not necessarily applicable to cyberspace as such, but we have certain adjustments of the effects test. We have the targeting test and the protective test. So the targeting test is sort of a middle ground between subjective territoriality and objective territoriality. Here, when we look at the targeting test, we verify whether the perpetrator intended to target a specific territory, a specific victim. And this is rather, it's more easily applicable in cyberspace, but its fallacy lies in the application of another standard, which is the intention of the perpetrator. And the intention of the perpetrator is, it's rather difficult to establish. It's not impossible, but it's rather difficult to establish. Finally, the protective principle is also an adjustment of the effects doctrine, and here it is generally understood as a tool for the protection of vital interests of the state, of the essential interests of the state. We have another fallacy here, because what is the essential interest of the state? Can we objectively define what is the essential interest of the state, or does the state exercising jurisdiction in cyberspace have the power to decide what are its own essential interests? So the protective test and the targeting test, these adjustments of the effects principle are rather more calibrated for extraterritoriality in cyberspace rather than the classic effects principle. Turning to enforcement jurisdiction, this is even more complicated to address. several hurdles impact enforcement jurisdiction in cyberspace. I will focus on just two notions, active self-defense and passive self-defense. And passive self-defense is usually territorial in nature, while active self-defense is extraterritorial in nature. So when we talk about passive self-defense is a traditional cyber defense mechanism. So it protects the environment from attacks. It's self-contained, and it acts as a shield for attacks coming from the outside of the territory of that state. The problem with passive self-defense is that it, in a way, encourages persistent attacks in order to penetrate the systems. So it's basically a contest between the perpetrators and the entities that defend themselves regarding technological advancement. And this is why cyber passive defense, which is territorial in nature, is the rule, but occasionally active self-defense might be necessary. Now, it is important to distinguish between active self-defense and offense. Offensive acts, active self-defense is not offensive in nature, it is not an attack. Active self-defense means that the state performing this type of activity tries to identify risks outside of its own territory. But while identifying risks outside of its own territory, of course, there's the danger of breaching international law, breaching the principle of non-intervention. So consent should govern active self-defense. To conclude my presentation, the current understanding of international law and national law as it is applied in cyberspace today works by analogy. We see concepts such as cybercrime, cyberterrorism, cybersecurity, cyber defense, concepts that are usually used when applying national and international law in cyberspace. The extraterritorial tests and the territorial tests also apply in cyberspace by analogy. So to come back to the question of our panel today, given my conclusion that extraterritoriality in a space that lacks territory is the rule rather than the exception, then the answer to these questions is yes. Should extraterritoriality be contained in cyberspace? The answer to this question is yes. We see already that the protective principle and the targeting principles are adjustments of already existing principles in order to contain the application of the extraterritoriality in cyberspace. The second question is, can it be contained? And the answer to this question is also yes, because cyberspace is today a domain that is characterized by tensions, and I found very challenging and thought-provoking the presentations of yesterday, particularly from my perspective, from the perspective of my topic. Cyberspace is physical and virtual. Cyberspace is public and private. Cyberspace is human and artificial. Cyberspace is territorial and extraterritorial. And all these tensions generate or should generate the calibration of existing norms of national and international law, and where necessary, new frameworks of national, but more importantly, international law in order to protect the interests of the relevant stakeholders. And one more minute to conclude. The multi-stakeholderism is essential for calibrating existing national and international law and for creating new norms in cyberspace. Of course, states, government organizations are involved in this process, but other entities, be it individual, be it non-government organizations, should be involved in the process of adjusting the existing framework. So my conclusion is that at least when we think about extraterritoriality in cyberspace, multi-stakeholder inclusion should be the key feature of the development of these legal frameworks designed to address the illegal activities performed in cyberspace. Thank you very much for your attention.
Thank you so much. So I know that we are now standing between all of you and lunch, but I believe we have been given at least a few minutes for questions if there are any from the audience. And I see several hands up, beginning, I believe, with Herr Robe. And then behind Herr Robe.
Thank you very much. My question indeed goes to you, Hannah, because I was intrigued by your very interesting ideas on extraterritoriality being a legal notion, about the legal space in which the state acts. That's true. And as a consequence, you say, in the era of globalization, this is necessarily about to change because our notion of sovereignty is about to change. And then I think so it becomes less and less important in practice. But what you then said is just my question, the amount of my question. Did I understand correctly that you say that common interests, global interests, are now the very subject matter of extraterritoriality? And could you explain this a little bit more? You said climate change is one example. We have talked a lot about, public interest norms. Would they all go under this idea? Thank you.
And just behind, yeah.
Merci.
Thank you. My question has to do with the notion of extraterritoriality. I would like to know what are the safeguards offered for the protection of this concept, such as the dehumanization of international law or the concept of extraterritoriality. You're being understood that sovereignty of states is more an outlook than a reality. And if we think about the position of certain states in the international arena and the question of the criminal responsibility of their nationals. Therefore, I'd like to know whether states have the ability to ensure the principle of reciprocity, which is important for the United Nations. In other words, the question of extraterritoriality or dehumanization of international law, wouldn't they be dangerous as regards the notion of the sovereignty of national states? Thank you.
Thank you very much, Louis Ströker, Harvard University. My very quick question to Thibault is, what are the benefits and challenges of extraterritoriality of EU asylum rules? Because I saw you wrote on refugee protection.
So maybe we can pause and have a first round of responses and then see how we're doing on time. Thibault, do you want to field that last one? Or?
Je peux, pardon, merci beaucoup.
Yes, thank you very much. I would just like to answer your question. So may I just check whether I understood your question? You're talking about American law governing asylum matters. Answer without a microphone. Now, in fact, I'm not sure that in respect of European asylum law, we're talking about extraterritoriality, we're talking about outsourcing, in other words, delegating the responsibility of carrying out controls to other states. And in reality, along the lines of what Mrs. Yassin was saying, European states, in fact, are tending rather to avoid to apply their own law in order to avoid that people arrive on their own territory. And I believe that the matter of extraterritoriality arises more from the standpoint of human rights. For example, with the Frontex operations, or in those cases where you have officials either of the member states or EU, in fact, satisfy asylum requests in third-party territories, and therefore there's a dilution of responsibility in the area of human rights, which in fact is rather difficult to identify.
Let me just say a couple of things that I think address parts of the first two, of both of the first two questions. So, Herr Hobe, when you're asking whether, now extraterritoriality is a tool to deal with common challenges, whereas before it did something else. So I actually don't see such a clear teleology to the development of extraterritoriality. What I think is that extraterritoriality is simply a framework that we use and always have used to deal with questions of state authority in whatever the then prevailing context of international law and sovereignty is, right? So if you look at the development of extraterritoriality as a concept way back at the beginning, it was used as a way to exclude states' abilities to regulate the behavior of ambassadors within their borders, right? So the idea was, well, no, actually, the ambassador isn't physically present in the host state. We will think of them as still present in their home state, thus, freeing them from the burdens of local, right? So that was at a time when we had much stricter understandings of the territorial reach of law, and so the concept of extraterritoriality was simply a fiction. It was a legal fiction that helped deal with sovereignty and regulation in that context. Then we have the kind of economic globalization, and we see changes in the way we talk of extraterritoriality, right? So, again, for a state to regulate things happening on its territory, but in ways that have impact in other countries, is that territoriality? Is it extraterritoriality? I mean, in a sense, who cares, right? Because what we're asking about is what makes it legitimate for a state to take particular action. So I think what's happening now in the desire to achieve certain, I will say, common goods, right? So protection of the climate. This is a common good. And how should we think of sovereignty of individual states in the context of the fight against climate change, right? It's, so I see our understanding of territory, authority, and sovereignty is always changing because of patterns of human behavior, right? So I think the concept of extraterritoriality changes with all of that, and it simply becomes a framework, right, to think about legitimacy and authority in the international arena. Yeah. Other.
No.
Please.
Thank you very much. My name is Eulalia Petit from Universidad de Sevilla in Spain. I would like to address just a question to Madame Yassin. Are we talking about the same topic when we talk about extraterritoriality and human rights? I will tell you why my question is said that way. Extraterritoriality is traditionally seen as the expansion of the state power, either in terms of legislation or jurisdiction, in terms of the court jurisdiction. So it's usually at the discretion of the state with the limits that have been explained. And it's supposed to rule the conduct of others, usually private parties, companies, etc., and to bring them to this state power or legislative order or jurisdictional order. When we talk about extraterritoriality of human rights obligations, we are talking about extraterritorial obligations and not rights, first of all. Second, that had not been decided or consented by the state because they have been developed as a rule through case law or a jurisprudential role when it's not foreseen in the treaties. I'm not against. It's not a question of being for or against extraterritoriality in human rights, but it's quite a completely different legal phenomenon as it's imposed in the onto the state, while the traditional extraterritoriality was an option for the state, well or bad seen. It depends on the period and it depends on the scope, but it's quite a different thing. Don't you think so?
Can I answer? How about let's collect one last question and then wrap up. Yeah. Oh, so, yeah.
Thank you so much for your panel. My name is Gail Lithgow and I'm at the University of Manchester. I had two questions. One is concerning the difference between legal space and physical space. And I wanted to ask whether territory was legal space or physical space. Because if it is the former, is there any need for the concept of extraterritoriality at all? If legal space is socially constructed, then there isn't a need for extraterritoriality as either a legal concept or legal framework in the first place. The second question was on the construction of cyberspace as somehow separate, as a separate domain to real space or physical space in some way. And so I was really intrigued by your presentation on this separation, because there's a lot of work being done on urban platforms or platform urbanism, which shows how much software and data is being used to construct our physical world. And so we are utterly entangled with this so-called digital space. And so is it time now to rethink this the origins of cyberspace that was constructed as the supposedly ungovernable separate space, whether that's a realistic dualism to uphold anymore? Thank you.
So, Farah, do you want to start, and then Victor?
So I would like to answer the question that you raised. I'm thinking about the concept of extraterritoriality.
Le concept d'extraterritorialité, pour moi, c'est comme les autres concepts de droit national.
You mentioned the change in sovereignty. I think now we're going from the traditional, let's say, traditional concepts and theories in international law to a modern concept. And this affects all areas in international law, to be honest. How does it affect extraterritoriality? I'm not saying that we are adding obligations to states. Their obligations, let's be clear, obligations are based on voluntarism, which means that their obligations are based on the conventions to which they are state parties. So we are not extending the scope of obligations. We are saying, we are simply telling states, you committed to this treaty, fine. You will be forced to follow this treaty not only in your territory, but in other places that are either under your control or where your actions can have some effect or some influence, or even over the individuals who are in those places. So yes, we are extending rights here. That's true. We are extending, and we are actually increasing the sphere of persons who benefit from this protection. But basically, this was not the intention. The intention was only to expand the scope of application of certain treaties to cover territories, not only within the very limited jurisdiction of states. I hope I answered your question.
Thank you very much for your question. So I think that this dualism is still necessary. This is not to say that cyberspace is a completely separate domain from the physical space, but we do have physical space and cyberspace. For example, if we think about critical infrastructures where servers are located physically, then cyberspace includes all these physical elements. However, if we look at social media, then we see a deterritorialized space. What I think is that it is important that we keep this dualism. It is important that we think in this paradigm of territory and of physical and virtual. But this is not to say that they are completely separate and that we should completely isolate them when addressing the existing norms and potential new norms. So, for example, if you talk about the use of force, the question is, what is cyber force? Can a state use force in cyberspace? And there's one school of thought that argues, well, we can use force through cyberspace, but only if the physical space is affected through the actions performed in cyberspace. On the other hand, we have another school of thought that argues, well, we can use force even in cyberspace without any physical effects in situations in which we have coerciveness, when we have resistance from the party that is affected in cyberspace. So the solution, from my point of view, is to keep this dual perspective. My initial title for the article was Tradition and Progress regarding cyberspace. So what I think is that we must still observe the traditional elements of space, territory, sovereignty, but we must also observe new spaces and calibrate them without ignoring the traditional ones.
And I would just add, and I'd let them go first because I wanted to think about your very, it's a very good question whether territory is legal space or physical space. So I think for purposes of the topics we're discussing, so, jurisdiction really and authority, I think it's kind of both, right? Because the salient, and I'm very much following on Victor's remarks just now, I think the salient question is whether there remains some kind of link between physical space in the world and sovereignty. And I think there does, because primarily because physical territory remains the site of physical action in the form of enforcement by a particular state. And as long as that is true, then I think there remains an aspect in which the physical reality of territory is still important, not just as a legal construct, right, but as an actual place in the world where certain things can happen and other things cannot happen. Oh, okay. I see our Secretary General rising from his chair. So thank you all so much for your attention, and looking forward.
Oui, toujours dans cette perspective de l'humanisation.
Now, along the same line of humanization of international and the Academy of International, it wouldn't be humanizing to oblige you to skip lunch. So we're going to have take a break. Thank you very much, Director of Studies, for conducting this work in a very limited time. Well, this book is about to be published. No, it's already there. So feel free to read it whenever you have some time. We'll resume here at 2 o'clock. We don't have any leeway this afternoon for technical reasons, except that I suggest we don't discuss the reports of sessions 5 and 6, which means that we have more time for each roundtable, an extra 10 minutes each. So we'll be discussing cyberspace as well as epidemics. See you soon. Thank you to the panelists.